members of the tribunal, friends. The earlier sessions have been so rich in detail, and this last session, this last session, Varisha's summation of recent judgments and trends in the Supreme Court, and of course Kapil's riveting speech, full of anecdotes, examples, and the lasting message that the judiciary really does not stand apart from society. Significant, and I really don't think I have very much to say. Maybe it will just be a short summation. Like all things political, social, and institutional, the judiciary is a mosaic and has been analyzed as such for a long time by many. Long ago, Dr. Rajiv Dhawan traced the Supreme Court and its trends as upholding the right to property with alacrity, but being rather tardy in upholding the right to personal liberty. I was privileged to be at a talk where Justice Chinnappa Reddy did a Marxist analysis of the Supreme Court, and through that, an analysis of the Indian polity. He said the Golaknath case, the case which upheld the abolition of privy purses, is a recognition that India had transited from the feudal state, but the judgment striking down back nationalization suggested that India was still in an early stage of capitalism. An interesting line can be traced of my dissents, a dialectic where dissenting judgments become a dominant opinion, and many, many kinds of analyses of the Supreme Court can be made. In fact, it will be seen that at times of crises, the court has generally stood by the executive. At other times, it has been expansive about liberty and accountability. During Mrs. Gandhi's time, in fact, the first call for a committed judiciary, I remember, came from Mohan Kumara Mangalam. The habeas corpus judgment in AD Jabalpur has embarrassed the Supreme Court then, continues to embarrass judges now. So, but what was hitherto a pattern amenable to conventional, if not always a comforting pattern, has had a quantum change today. Judicial slings and arrows have become outrageous beyond description. If I were to sum up these slings and arrows today, I would do it under three heads. One, abdication. Two, distortion. And three, I've been trying to find a mild description, but the mildest I can find is active balefulness. Balefulness towards civil society. Abdication, as examples, Varisha spoke about what happened after the abrogation of Article 370. Hundreds of Kashmiris and other activists are in jail. The habeas corpus petitions are pending. The Supreme Court has not decided the challenge to the abrogation of Article 370. It's lying in cold storage. We don't know whether it will be heard, when it will be heard, and what the outcome will be. So you want to impose upon the people of Kashmir the imperatives of statehood. You do not want to recognize for them the imperatives of personhood. Other high courts are overladen with habeas corpus petitions. Many in Kashmir The meanwhile is under detention, informal detention. There are paramilitary forces and policemen outside his house without a formal order of detention, I'm told, which he can challenge. And the Supreme Court is not listening to the challenge to the abrogation of Article 370. Another example that comes to mind is Nandini Sundar's petition on Chhattisgarh. In 2011, the Supreme Court gave a landmark judgment holding state vigilantism unconstitutional. The Supreme Court also directed immediate lodging of FIRs in many cases of serious offences by the security forces and by state-sponsored vigilantes. Since then, complaints which arise not merely from on our saying, but from NHRC reports, from reports of other institutions, the Child Rights Committee, etc. Nothing has happened in those FIRs, and we're trying to get the Supreme Court to hear the matter. We're not getting a hearing. So abdication is one active way in which there is an assault on rights and civil liberties. The other is distortion, because distortion of established principles of jurisprudence, distortion of fact and law. Kapil said, you are following a colonial code of criminal procedure. I, for my part, would be grateful if they even followed the criminal procedure. Established norms of evidence are being distorted in legislation after legislation, which the Supreme Court is endorsing, of the PMLA judgment you heard. In the Hareen Pandya case, I will mention it very, very briefly, a complete impossibility set up by the CBI. It is impossible for a man to get shot inside a Maruti car. He could not have been shot like that unless he was out in the open hanging upside down. These facts were distorted by the Supreme Court by an endless benefit of the doubt given to the prosecution, but it could have happened, and so on. It rarely does one come across a case of absolute impossibility. In the Hareen Pandya case was one such case. But that was not all. Since it was the final stage, it was brought before the Supreme Court that there is enough material, cogent material, certainly worthy of further scrutiny, but there were complaints from family members, there were statements of investigating officers suggesting that the investigation done by the CBI was deliberately blind, was deliberately misleading, and instead of taking it seriously, the council had brought it to their notice. Prashant Bhushan was castigated. So these are some examples of distortion of the active balefulness of the Supreme Court. I think you've heard chapter and verse, Himanshu Kumar and Teesta Setalvad. So well, and Kapil may be right that the Supreme Court or the judiciary signifies a social reality. The pusillanimity is perhaps reflective of us all as a society. The fact remains that seldom has such a complete identification with executive expediency, executive arrogance, executive presumption been seen, open and complete. Seldom has it been seen. So I don't know, Honorable Tribunal, you must say, when salt loses its savour, etc. Let's see. We hope for wisdom from you. Thank you.